Hello, and welcome to Lesson 2 of the Power of PMAs course. Today, we will be learning about the history of PMAs. This is one of the most important lessons in this course, and one of my favorites, because we are going to dive into the long, well-documented history behind PMAs. You see, many people are under the misperception that PMAs are a new concept or idea. However, the truth is that PMAs are the original way that people conducted their businesses, educated their children, treated their sick, and exercised their religious freedom. People simply shared their experience and their expertise with others without government interference or asking for government's permission to do so. Throughout history, people have always operated through private contracts and agreements, both written and verbal. Back in the day, you would ask your neighbor who was a handy carpenter to fix your roof, and in exchange, you would give him a cow. With a simple handshake, your verbal agreement was considered to be binding, and both parties were expected to honor their word. Before, people were free from government's red tape and from government's restrictions. We were free from its limitations and licenses. And because we were free, we were also free from government oversight and overreach. Now, you may be asking yourself, well, if that's the case, then why haven't I heard about PMAs before? And the simple answer is you have. The National Association for the Advancement of Colored People, or the NAACP, is one of the most famous private associations that has been in existence since 1909. The American Medical Association is another private association, and all of the local, state, and federal bar associations are also private associations that operate under their own rules instead of under public law. Another case where private associations are popular is in states like Texas that have dry counties where it is illegal to buy or sell alcohol. While it is illegal for the public to buy or sell alcohol in a dry county, if you are a member of a private social club or a private drinking club in that same county, you are able to buy and sell alcohol without any problem because the government does not have any jurisdiction in the private domain, which we will discuss further in Lesson 4. Prior to the 1950s, there were not many cases involving PMAs because the government didn't really try to overstep its bounds in regard to private associations. However, since the 1950s, there have been many cases that have been documented in our courts which have upheld the rights and the protections of PMAs. These are some of the most important cases to date, which will be essential for you to know, and I'm going to share them with you now. Please feel free to do your own research in order to add to this list. United States versus Peters, 1809. If the legislatures of the several states may at will annul the judgments of the courts of the United States and destroy rights acquired under those judgments, the Constitution itself becomes a solemn mockery, and the nation is deprived of the means of enforcing its laws by the instrumentality of its own tribunals. We make a mockery of the Constitution when we allow the state to destroy our rights as free people. Hale versus Henkel from 1906. This is a long one, but one of the most important cases regarding the rights of freedoms of the individual, and I will read it to you now. There is a clear distinction between an individual and a corporation, and the latter, being a creature of the state, has not the constitutional right to refuse to submit its books and papers for an examination at the suit of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation, so far as it may tend to criminate him. He owes no such duty to the state since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land, long antecedent to the organization of the state. So even before the state existed, our rights existed. And those rights can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure, except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. Upon the other hand, the corporation is a creature of the state. It is presumed to be created for the benefit of the public. It receives certain special privileges and franchises and holds them subject to the laws of the state and the limitations of its charter. Its powers are limited by law. It can make no contract not authorized by its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that a state, having chartered a corporation to make sure of certain franchises, could not, in the exercise of its sovereignty, inquire how those franchises have been employed and whether they have been abused, and demand the production of the corporate books and papers for that purpose. Sterling versus Constantine, 1932. The governor of a state is subject to the process of the federal courts for the relief of private persons when, by his acts under color of state authority, he invades rights secured to them by the federal Constitution. Again, we see that the governor can be subject to prosecution if he attempts to invade our rights which are secured to us by the Constitution. The state has no authority to override the Constitution, which is the supreme law of our land. Thomas versus Collins, 1945. The task of drawing the line between the freedom of the individual and the power of the state is more delicate than usual, where the presumption supporting legislation is balanced by the preferred position of the freedom secured by the First Amendment. Restriction of the liberties guaranteed by the First Amendment can only be in a clear and present danger to the public welfare. Freedom of speech and of the press, and the rights of the people peaceably to assemble and to petition for redress of grievances, are cognate rights. Here we find the one condition when it comes to PMAs. Our liberties can only be restricted when there is a clear and present danger to the public welfare. This case reaffirms that our First Amendment rights are cognate rights. Cooper versus Aaron, 1958 says, "No state legislature or executive or judicial officer can war against the Constitution without violating his solemn oath to support it. If the legislatures of the several states may at will annul the judgments of the courts of the United States and destroy the rights acquired under those judgments, the Constitution itself becomes a solemn mockery." The NAACP versus Patterson, 1958. Freedom to engage in association for the advancement of beliefs and ideas is an inseparable aspect of the liberty assured by the Due Process Clause of the 14th Amendment. And last but not least, in 1971, the courts ruled in Baird versus State Bar of Arizona that a state's power to inquire about a person's beliefs or associations is limited by the First Amendment. There are other cases that have been documented in the courts in the United States. I invite you to continue to research these cases and other cases on your own in order to have a better understanding of our rights and our freedom to associate. This concludes Lesson 2 of the Power of PMAs course. This course is based on the Power of PMAs ebook, which is available for free at www www.peacefulworldschoolers.com, as well as in the resources section of your course.